Sorry, I won't do that. It's the last one.
No, no, no.
Who's
no.
transcribing?
Thank you.
Taking all my jobs.
You don't have to go to see. Hello, Kate. Thank you.
Is the court ready? Shall I go on? Just check. Are you?
Court rise if able. Appeal in the matter of J.C. Bamford Excavators Ltd and Manitou UK Ltd and another.
Thank you. Mr. Silverleaf, before we go any further, we need to discuss whether an order needs to be made under Rule 3122.
We have agreed that an order should be made if necessary.
Right, and we hope you've agreed between you that someone will draft it.
I'm sure we will be able to provide you with a
Very
draft.
good. So for the information of anybody not directly connected, these proceedings will be conducted so far as we can in public, but nothing is to be published at all about what is said at this hearing until at least the conclusion of the case, which is the handing down of the judgments at the end of the process.
I've discussed the issue with my learned friend, and he and I both think that we can present the arguments without mentioning the confidential information.
But that was the view that we have come to, in that the judge very carefully did that in his
Obviously,
judgment.
we'll both have to point you to passages in the documents which
Yes.
say what it is.
Yes.
But
Yes.
you've had the benefit of scouting arguments which set it out. And,
Yes.
I think we can deal with it. I'm proposing essentially to use the rubric criterion X,
Yes.
which is what's in the judgment and everybody accepts is a sufficient identifier for the purposes of the argument.
Yes, and I imagine Mr. Nicholson's comfortable with that.
Yes, I will.
Yes. Good. The other thing we're itching to know is whether you've agreed some form of timetable for the submissions.
Oh, we were assuming that we had, I thought we were listed for half a day to a day.
Yes, you've certainly got the day.
Yes. I'll be very surprised if we need the whole day.
Well, sometimes we are surprised, but so
I'm notorious for underestimating cross-examinations. I'm a bit better with submissions.
good. Well, we'll see how we go. And,
Unless the tribunal has enormous numbers of questions, I think we should be able to get.
good, good. And you're comfortable with that, Mr. Nicholson?
Yes,
We're extremely grateful for the many skeleton arguments that have been filed, which we've read, and obviously the judgment have gone into the background document. So we start with that knowledge. The only other matter of housekeeping to raise is your application to
Yes.
amend the notice and then the grounds. Again, I don't know whether you've had any discussion as to whether that needs to be dealt with as a preliminary matter, or we proceed and hear your submissions and just see whether there's a need, if there is a dispute about it, to determine that issue.
My position is that, as far as we can see, the objection to the amendment is based upon a misunderstanding of our position. On our appeal, our position is, as it has been throughout, that the three heads of information stand or fall together, because that's how they were treated below, that's how it was argued, and it is now too late to raise it. On the cross-appeal by Manitou, we do not suggest that head 2 and 4 will be made public on the basis of the balance of factors in Lillian Lycos. We accept that the only factor under consideration is criterion X. Right. So the position is exactly as it was before the judge below, and I'm hoping that we can deal with it very briefly at the end if necessary.
Yes. Well, that's helpful, and I'd imagine that, Mr. Nicholson, you don't want to push the determination of the application to amend now.
My Lord, no. With the clarification my learned friend has made, the finer points of the paragraphs of the judge's order that would need amending.
Yes.
If on the basis of either side's appeal is something that can easily be worked out, so there's no need to deal further with the application to amend.
Good. Thank you. I imagine my lord and my lady are content to proceed on that.
Is that all the preliminaries, Michael?
Good. Right. So now we can start.
Yes. We have set out the underlying facts in our skeleton. I wonder if I could just spend 5 minutes showing you the relevant bits of the patent, because this is all about machines called telehandlers. And I think the court's understanding of the issue will be assisted by seeing what the machine is and how it works. So if you go to the patent, which is at supplementary bundle number 1, and look at the introduction in paragraphs 1 and 2. You will see that the invention relates to a controller for a machine, including a load handling apparatus, a machine including such a controller under control method. Machines including a load handling apparatus, paragraph 2, typically include a front and rear axle supporting the machine body on which the load handling apparatus is mounted. Wheels are normally coupled to the front and rear axles, the wheels being configured to engage the ground and permit movement of the machine across the ground. If you go to the figure 1, there's a picture of the machine, and these are typified by machines. The term that is normally used for them is telehandlers, and you'll see that
I'm having trouble finding figure 1.
Figure 1, it's on page 14 of the bundle. The machine consists of a chassis which sits on 4 wheels. There's a cab for the driver, which you can see. And beside the driver's cab, there's a hydraulically operated lifting and lowering arm, which goes up and down and can be extended. There's a hydraulic piston in the middle of the arm that you can see that allows the arm to be pushed in and out as well. It can be used with a number of tools on the arm. The most used tool is a set of forks to carry a load, as depicted here. And it is immediately apparent when you look at the machine that as you raise and lower the arm and extend the arm with a load on the forks, the balance of the machine will change. And what this is all about is keeping the machine within safe load limits so it doesn't tip over. And at the trial we went into large numbers of regulations which exist to try and ensure safety of these machines, but we don't need to be concerned with that. If we go back to the text at page 2 of the bundle and pick it up at paragraph 3, what I've just shown you is described. The load handling apparatus includes, for example, an extendable lifting arm movable by one or more actuators with respect to the machine body. The lifting arm includes a load carrying implement to carry a load. Such a load is carried by the load carrying implement can be moved such that a load carried by the load carrying implement can be moved with respect to the machine body by the lifting arm. Movement of the load produces a moment of tilt about an axis of rotation of one of the front or rear axles. Alternatively, a moment of tilt may be induced about another axis, where, for example, stabilizers are used to stabilize the body relative to the ground. Extension of the lifting arm in a forwards direction, particularly when carrying a load, induces a moment of tilt about the axis of rotation of the front axle. As a result, the portion of the machine and load weight supported by the rear axle decreases. In order to ensure that the machine does not rotate about the front axle to such an extent, the wheels coupled to the rear axle are lifted from the ground surface, i.e. to ensure that the machine does not tip. When the load on the rear axle reduces to a threshold level, a safety control prevents further movement of the lifting arm. An example of such a machine can be found in previous EP patent, which is, I can tell you, Lordships and Ladyship, an earlier patent of my clients, colloquially known by the parties as soft stop. So if we go back to the figure at page 14, what's being described is you will see from the figure that the load is outside the wheelbase of the machine. So as the load is extended forward, a tipping moment is created around the front axle, C, marked on the drawing, and that reduces the load on the rear axle. And there is a load sensor on the rear axle, which the control system receives the input from. And when the load on the rear axle drops to a level at which the machine risks tipping, further movement of the arm in a direction that would increase the moment of tilt is prevented. That's the basic principle. It's as simple as that.
And it has to be specific to the particular operation on the day,
Yes.
rather than a rigid thing, because
Yeah.
if it's a very heavy load,
Yes.
presumably the weight on the rear axle
The
lifts
beauty of measuring the load on the
stage.
rear axle is it compensates automatically for the size of the load, the extension of the arm and the angle of the arm, because the rotational moment, the tipping moment, is dependent on all those things.
Yes.
And the load sensor is measuring the result
Yes.
rather than any of the inputs. It's measuring the output.
Yes.
So it's
And it's measuring it at the point, actually,
At the point at which
where the danger is.
yes,
Yeah, yeah.
precisely.
Yeah.
Now, the specification goes on to explain in paragraph 8, a problem arises, sorry, I'm back on page 2, because in order to remain within safety limits, the threshold level which is selected for use by the safety control is overly restrictive for certain lifting arm positions, preventing the lifting arm from being moved into positions which do not actually risk tipping the machine. And so what is done is to vary the threshold at which the safety device prevents further movement, in dependence on the angle of the arm.
Yeah.
Because the higher up the arm is, the greater the risk of tipping, and therefore the more restrictive the control system needs to be of movement of the arm. It needs to cut off further movement at a higher threshold.
It unnecessarily restricts the flexibility of the
Yes.
operation.
In order to keep the machine safe at high angles, you need to cut the movement of the arm off at a relatively high threshold on the rear axle, whereas at low angles you can let it go to a lower threshold without risking tipping the machine. And the invention is claimed in claim 1. There are integerized versions of the claim for ease of reference. That's probably best if I take you to the judgment below. Before I do that, I should show you the graphs of the way in which you can change the threshold. And those are set out in figures 4 to 6 at pages 17 and following. And so you'll see that in figure 4, the threshold can change continuously with angle. In figure 5, it can change between two maximum and minimum points, depending on the position of the arm. And in figure 6, you just have two different thresholds, which change at an angle. So the invention covers various different ways of restricting the movement according to angle. The integerized form of the claim is in the judgment of the trial judge at supplementary bundle 3, supplementary bundle tab 3, page 112. Sorry, that's rubbish. Tab 4.
Sounded good. Tab 4. Yeah, 112 is tab 4.
Yes, I'm sorry. I don't know why my note says tab 3. It shouldn't. So the claim is to a controller for a machine comprising a machine body, a load handling apparatus coupled to the machine body, movable by a movable actuator, respect to machine body, whereby the controller is configured to receive a signal representative of the position of the load handling apparatus and a signal representative of the moment of tilt of the machine. That's the load on the rear axle. characterised in that the controller is further configured to issue a signal for use by an element of the machine, including the movement actuator, which in response to the signal issued by the controller is configured to restrict or substantially prevent a movement of the load handling apparatus. When a value of the signal representative of the moment of tilt reaches a threshold value, the next features are important, the threshold value being dependent on a signal representative of the position of the load handling apparatus with respect to the machine body, wherein the signal representative of the position of the load handling apparatus is a signal representative of the angle of the load handling apparatus with respect to the machine body. So it's the angle of the load handling apparatus is, we call it generally an arm because it's simpler. Obviously the claim is more generalised. And then the thresholds are set out. The threshold has a first value corresponding to a first angle with respect to the machine body and has a second value corresponding to a second angle load handling apparatus with respect to the machine body. The first value being less than the second value and the first angle being less than the second value. I think it is common ground that what that represents is a control system which cuts off the movement, further movement of the arm that would increase the moment of tilt, reduce the stability of the machine, more restrictively at high angles. In other words, at a higher threshold at high angles than at low angles. A lower threshold is applied. So you can get the machine closer to its limits at low angles without risk. Now, the issue in the action concerns principally the requirement of integer f, the claim that the signal representative of the position of the load handling apparatus is, quotes, a signal representative of an angle of the load handling apparatus with respect to the machine body. And the trial judge says at 106, integers b and f have to be read together. So the signal is representative of the angle of the arm with respect to the longitudinal axis of the machine body. We say that Manitou's machine uses such a signal. The trial judge has found otherwise. That finding is the subject of the main appeal to be heard in January next year.
Yes, it doesn't matter for our purposes, but just so as I've got the full picture, can you tell me what's the scope of the appeal that's being heard in January? Is it just infringement of EP382, or are there other issues?
There are other issues as well.
Right.
Do you want to know what they are?
Well, just quick summary.
There's a cross appeal on validity of 382.
Right.
And there is one other patent that is, there were 3 patents in the action, 065, 965 and 382. 065 was found invalid and we're not appealing that, despite my having spent some time at the European Patent Office validating it originally, but we've decided that it's better to leave that one alone. 965 was held invalid. We say the judge misunderstood and misapplied the evidence, and he should have found it was not obvious. So there is an appeal on validity of 965 and cross appeals on validity and infringement of 382.
Thank you.
Have I missed anything? Manitou's control system is described in some detail in the confidential PPD. It's at Supplementary Bundle tab 2. I hope I've got the right reference this time. Yes, this time I'm right. This is marked to show the confidential information. And it starts at page 22 of the bundle.
Can you enlighten me as to the colour coding of this?
I was about to do that.
In particular, I was mystified by what the yellow coding was. I thought I worked out what green and blue were, although I may be wrong, but I was mystified by yellow.
Yes. Green is that which is agreed to be confidential. Blue is that which is disputed. Yellow is that which was originally alleged to be confidential but is now accepted not to be. All right, Lord, I was as baffled as you were. I had to check. I couldn't remember why there were things still marked in yellow. The relevant part of the PPD concerns a particular type of machine and starts at page 16 of the PPD, page 37 of the bundle.
Thank you.
At paragraph 68. And what it describes is how the threshold value is generated in this type of machine. And you see that the specific formula which is used is agreed to be confidential. We say that the parameter on the basis of which it is calculated should not be kept confidential, but only the parameter. And I should make clear that we do not suggest the precise detail of how the system is configured or the method used to calculate the threshold lack the necessary quality of confidence to be protected. All we say, based on Professor Plummer, who gave unchallenged evidence for us, is that the suitably qualified engineer is able to see from inspecting a machine freely placed on the market by Manitou that the parameters that are used in the operation of the control system. We say that such information cannot be confidential, and there is accordingly no basis on which it should be redacted from the public judgment. That is obviously particularly so where the public judgment cannot be understood without knowing at least what the parameter is. Now, the threshold is generated by something called criterion X, which is identified in paragraph 71. And you'll see that the criteria are based on the signals set out in paragraph 69. So that's the stability signal, which is the way that Manitou describes the load on the rear axle, and criterion X. And then you have a formula in 71. For present purposes, we don't need to worry about the fact that this only operates above a certain level of load on the machine. Below an initial threshold level, the system doesn't cut out at all because you're sufficiently far from the safety limit, it doesn't matter. But once you rise above that, the system cuts in, and you'll see in 71 how the maximum value of criterion X is calculated, and we fully accept that that's entirely confidential. We also accept that a mechanical engineer looking at the machine, whilst he or she would be able to deduce the nature of criterion X from the behaviour of the machine, would not be able to determine that particular formula. So the value of the information in terms of designing a machine is pretty limited. So what happens is, as you see in 72, the control system, longitudinal load moment control is what that stands for, compares the measured value of criterion X with the maximum value of criterion X, and cuts off movement if the measured value reaches the maximum value. I think it's fair to say that is probably all you need for the purposes of understanding what we're discussing on the appeal. I can come back to the other subsidiary operations which apply in the other mechanisms that also operate, but that's the one with which we're concerned. Now, it is important to note that the way in which the functionality is described does not enable one to determine how a machine will behave in practice, because there's no data given at all. And that at the trial, Professor Plummer had to do considerable work to demonstrate the behaviour of the machine using this methodology set out in paragraph 71. That aspect of his evidence was not materially challenged by Manitou at trial. Indeed, they ultimately conceded, as noted by the judge, that the control system achieves the same result as the method claimed in the patent in suit. And you'll see that in the judgment annex, which is at core bundle 9, I hope I'm right in saying, tab Core Bundle 9, Core Bundle Tab 9. This is the interim public version of the infringement judgment, the judgment annex which deals with infringement. And you'll find that in paragraph 51 of the judgment, of the annex, on page 72. The issue on the main appeal and the confidentiality question now before the court are encapsulated in the trial judge's finding on infringement by equivalence at paragraphs 49 and 50 of the judgment annex. So actually, I should probably start with paragraph 25. System A, at the bottom of page 65, is the system that measures criteria X. And paragraph 25 explains that System A causes an abrupt stop to arm movement when a value of criterion X, threshold value Gx, is met. Gx is set according to a formula which has been redacted. And over the page, where the stability signal increases to reach the maximum stability threshold, Gx is a particular value and movement is prevented and lessened until the stability signal decreases. So if we go back to 49, what the judge says is, pick it up at 48, the variant, the controller in the bottom of page 71, in Manitou's configuration C machines is by common consent more permissive of arm movement as arm angles which are less likely to threaten the stability of the machine. He then says it's achieved in a different way. The Manitou controller shares with the inventive concept of 382 the measurement of the moment of tilt, but the signal representative of the moment of tilt, the stability signal derived from the rear axle center, is monitored not for another criterion, but for criterion X. When the threshold is reached, the controller causes arm movement to stop abruptly. Thus, A, the relevant threshold is in criterion X, not in another criterion, and B, it is not varied by reference to the angle of the arm, but by reference to something else. He goes on to say, as a matter of physics, criterion X is dependent in part on the angle of the arm. Therefore, criterion X, and thereby the value of Gx, the threshold, is in part dependent on the angle of the arm. It's also dependent on a number of other parameters. However, there is no signal, he found, representative of the arm angle which, by itself, directs changes to the value of Gx. So there's no dispute between the parties that the value of Gx, the threshold value, changes with the angle of the arm when the arm is moving and is then stopped. But the Manitou say, and the judge found, that that is not enough because the signal which is used is not, in his finding, a signal representative of the angle. We say, actually, properly understood it is, and that's the subject matter of the appeal.
But if I've understood it correctly, and without mentioning what the other criteria might be, the aspect that marks Manitou's control system out is, as well as the angle of the arm, there's another criterion,
yes,
which is measured. And although the focus of both the JCB machines and the Manitou machines is to look at the effect on the rear wheel load, this other criteria is specific to the Manitou.
There is no additional measurement taken. It is that the measurement they use is dependent both on the angle of the arm and on other factors. And if I may put it very, very simply, we say this is a classic example of ingenuity added to robbery. They're using our invention, but they're doing it in a way which allows them to add other features. But they're still using our invention. The judge found otherwise, and obviously we'll argue that out in due course. For present purposes,
what this appeal is all about is whether the
thing they've
added should be kept confidential, or the aspect they're measuring.
What they're measuring, the question is whether the parameter that they are measuring should be kept confidential, and which they use to achieve this outcome.
Yeah. Now, is it also So that it's A, the parameter they're measuring. Is it also how they do it?
In the detail.
The detail.
No, the detail we accept is confidential.
Right. And that's
just the parameter.
Right.
On their appeal, that becomes the fact that we say only limited information is not confidential becomes important in striking the balance. But for the purposes of my appeal, all we're concerned with is whether that information is confidential. Yeah. What I've just shown you is the interim public version of the annex to the judgment. That is the version agreed by Manitou not to contain confidential information. So everything I've just read out to you is already in the public domain. The full text of those paragraphs, which will be published if this appeal succeeds, is in the previous annex, I think page 59. Yes. So if you want to know exactly what they're doing, page 59, tab 8 of the core bundle, 49 and 50 are there set out in full. Obviously, I won't read them out.
No.
But you can see what's been deleted by comparing what's on page 72 with what's on page 59.
Yeah, that's what I understood. Yeah.
So you can see from that comparison what the issue on confidentiality is. It is just a single parameter. Now, the evidence, and I suppose I can also say, in relation to what is in the PPD, the material coloured blue reflects the difference between the parties. The material coloured green, everybody agrees, is confidential. The material coloured yellow, Manitou now accepted and be published. The evidence in relation to the confidentiality of that material on the application before the judge was given for Manitou by their solicitor, Mr. Bevan, and for JCB by Professor Plummer, who was our expert mechanical engineer at the trial. We find that evidence in the supplementary bundle at tabs 6 and 7, respectively. The key evidence is from Mr. Bevan, runs from paragraph 11 to paragraph 20. Again, I would prefer not to read it out, but just to draw to the court's attention that it is basically saying that there is no other system which uses criterion X. They rely on the fact that I said it's clever.
Very
But
clever.
that doesn't mean
Very clever.
very clever. Doesn't mean it's not an infringement, of course. And they say that they should be able to protect the innovation of their engineers.
So would you wish us to take time now to read that? I'd certainly mark
I
that.
think I'm going to come back to the facts. So I'm really just drawing to your attention what the evidence, where the evidence is to be found at this stage. The conflicting evidence from Professor Plummer is in the next tab, and it is essentially the key parts of the evidence are paragraphs 3.2 to 3.6, where he sets out what a mechanical engineer could deduce from the machine by operating it and observing what sensors it has. And the thrust of his evidence is that at 3.5, the engineer would be able to work out how the angle of the arm can be used to vary the cut-off threshold using criterion X. And in the last two sentences, he describes a particular calculation, which you will notice is not exactly the same as the one used by Manitou themselves, but it uses the same parameter. He then points out in paragraph 3.6 that it's quite complicated to implement a system using that parameter, and therefore the engineer would be unlikely to arrive at the way Manitou does it. But he points out in the final sentence, 3.6, that a calculation which involves measuring criterion X is the only available parameter to obtain the outcome that Manitou achieves.
Yes, unless you're using some detection,
Yes.
a sensor of some sort.
Yeah. Well, what he says is you inspect the machine, you discover there are no other sensors, and you are left. I probably shouldn't say this, but Sherlock Holmes used to say, once you have eliminated everything else, that which remains is the answer. And as what Professor Plummer says is, you look at the machine, you see what sensors it has on it. The only sensor that is available that can be being used to achieve the outcome that Manitou are achieving is the rear axle load sensor, and it is by measuring criterion X.
Yeah. Elementary.
Elementary. So what we say, I'll come back to it in more detail in a moment, is that the correct conclusion is that information is not confidential. Can I, with that introduction, just run through the law, because in our submission there is a very clear distinction between circumstances in which using an information in a document, which can be deduced, which information can be deduced from other sources or ascertained from other sources, will constitute a breach of confidence, and circumstances in which it won't. And the starting point is that in order to appreciate the difference between what is and what is not properly protectable by a claim for breach of confidence, it is essential to recognise that where a claim is made in relation to information, which is, as a matter of fact, available to, I will say, the relevant public, in other words, member of the public having the necessary skill and expertise to understand it, by observation or inspection of a machine freely placed on the market, there has to be a misuse of something. The misuse typically arises from the wrongful, illegitimate or unauthorised, that is without permission, use of information contained in a document which has been imparted in confidence. When there is wrongful use of such a document, the shortcut obtained by using it constitutes the breach of confidence. Where, however, there is no wrongful or illegitimate act, there is and can be no breach of confidence. That distinction is the one made in both Mars and Force India. The distinction does not depend upon whether or not the information has at the time of assessment been obtained by observation or reverse engineering. It depends upon whether it can be so obtained. If it can, then the information is not confidential, because it is available to any member of the public who wishes to obtain it. What is, the information per se is not confidential. What is confidential and may not be used without permission is the document, and therefore the information as contained in the document. The position is no different from a book on a library shelf. The information it contains is available to the public and therefore not confidential, whether or not anyone has actually picked it off the shelf and read it. Manitou's argument, and we say respectfully effectively the judge's judgment as well, ignores the requirement for misuse of a document by eliding it with the result or consequence of that misuse, the obtaining of a shortcut. Without a finding that the shortcut arises from misuse of a document, which the wrongdoer should not have used, there is no basis for the claim. The essential error in Manitou's argument can be seen from paragraphs 16 and 18 of its skeleton. If I turn to those, they are in the core bundle at paragraph 15. At page 163. No, bottom of page 162. So, having set out the part of the relevant text from Mr. Justice Jacob, as he then was, judgment in Mars, in paragraph 15, they move to describe what they say was going on. And 16, they say, Mr. Justice Jacob is here dealing with confidential information, and rightly points out that the form of the information is important. In the present case, the question of confidentiality is not one about whether the information has been made available to the public, but whether it has been made available to the public in that form. They then refer to the judge below's quotation of my Lord Justice Arnold's judgment in Force India. And then at 18, again, as in Mars, the court is not simply asking the question as to whether the information has been made available to the public. It is necessary to focus on the form when the information is contended to be confidential in that form. What is important is whether the allegedly confidential form enables the information to be obtained in a way that amounts to shortcutting a process of reverse engineering, decryption, detailed inspection, deduction, or the like. What matters is not whether the information is merely derivable, but whether information in the derived form has been published. Put another way, does having the information in this form constitute a shortcut to deriving it from what has been made available to the public? Now, that last sentence puts in quotation marks, does the having the information in this form constitute a shortcut? It is worth noting that as far as we can see, although it's put in quotation marks, it does not derive directly from any of the authorities cited. It is also worth noting in our submission that the proposition contains within it the seeds of its own destruction. It acknowledges that the information in question is in the public domain, just not in that form. If that is so, the fundamental principle, the information itself is not confidential, must apply. It can therefore be seen in our submission that Manitou's proposition does not represent the law. It is, in reality, in our submission, a partial exegesis of the principle applicable when confidential information is used as a springboard. I will turn to that in just a moment, but I think we should start with the true principle to be applied in determining when an action for breach of confidence will lie. The principle can be taken directly from the formulation of the necessary elements to found an action for breach of confidence, set out by Mr. Justice McGarry, as he then was, in Coco and Clark. That's in the authorities bundle, at tab 5, page 50, in the first red-lined paragraph. It is a principle that has been repeated, endorsed, and approved on dozens, if not hundreds of occasions in subsequent cases. 3 elements are normally required. The information, itself, in the words of Lord Green, the Master of the Rolls, Saltman, must have the necessary quality of confidence about it. Secondly, that information must be imparted in circumstances importing an obligation of confidence. And thirdly, and very importantly in this case, in our case, there must be an unauthorised use of that information to the detriment of the party communicating it. The unauthorised use or misuse is an essential element of the claim. Without it, no claim arises. As I said, that principle is hallowed. It has been repeatedly cited and endorsed by the courts at every level. By way of example, my Lord Justice Arnold cited it in Selgard and Shenzhen in the authorities bundle, tab 14, page 354, paragraphs 21 and 22. I don't, unless you want me to, I don't propose to turn that on. The principle in our submission therefore has no application to the facts of the present case, where there is no question of misuse. And I should, as an aside, I should say, my Lord Justice Arnold has very helpfully drawn our attention to a number of materials in relation to the Trade Secrets Directive, and an article of which he is a co-author, which cites a number of authorities, indicating that information which is derivable by reverse engineering may still be confidential. They are all cases, in my respectful submission, where the information is used as a springboard. And the result of that is quite important, because it means that what you are protecting the possessor of the confidence against is misuse of the document as a shortcut to obtaining the information from the source where it is available in the public domain. Without that misuse, without that misuse there is no cause of action. And it is also important to appreciate that the effect of the relative or limited confidentiality thereby granted to the document is that the relief to which a claimant will be entitled in making such a claim is limited to the benefit obtained by the springboard. I'll come back to that in a little more detail in just a moment. The judge in our submission was wrong in paragraph 25 of the judgment below when he held that the principle applies to the present case. He failed to realise that the key distinction is the requirement for the unlawful use of the information in the document, even though he himself rightly used that word to characterise the nature of the shortcut. If you go to paragraph 25 of the judgment, where's the judgment below? Now there's the core bundle, I just can't see. Tab 11, thank you. Tab 11, core bundle.
Page 81.
Sorry, Lord, 81.
Page 81 and 25.
Thank you very much. If you read that paragraph, in my respectful submission, he actually gets the analysis wrong. As he points out, an owner of a machine is entitled to find out how it works. They can do what they like with it. That information will not have been obtained in breach of confidence. Exactly the same information may exist in a document. Another party's act of using or disclosing the information as derived from the document, so he's got the point, will be in breach of confidence if such an act permits the exploitation of the information by means of an unlawful shortcut, i.e. without having to bother with the work of dismantling reverse engineering. Looked at in another way, the information as recorded in the document retains its quality of confidence because it is in a form which makes an unlawful shortcut possible. And what the judge has correctly identified there, but then failed to apply in our submission, is that for there to be a claim for breach of confidence, there has to have been an unlawful, unauthorised, or illegitimate use of a document which has been imparted in confidence. Where you don't have that, there is no claim. And this case does not involve the unauthorised use of a document at all. The question is whether the underlying information is in and of itself confidential.
So it's just trying to follow this. Obviously, paragraph 25 is very much at the centre of Manitou's response to your appeal. It's a matter of form.
Yes.
There are documents in which criteria and X are described, but we're not dealing with those. What we're dealing with is the judge creating a new document in which the same information is put, and it's that step of the judge putting in the public domain, if he does, the information that would otherwise be confidential, because all the other documents with it in are confidential, that provides the shortcut.
Well,
and that's what nevertheless needs to be protected by confidentiality.
That is what Manitou say. But the problem with that is that it requires, for an action to lie in such circumstances, there has to be some act of misuse. In other words, information has to be imparted in confidence in the document. And the document then has to be used without the permission of the imparter. And if you obtain the information from another source, you are not misusing the document. And it doesn't matter whether that source is one that is itself public.
But sorry, I didn't mean to cut across you, but is the difficulty of comparing what's said in the authorities with what we're actually looking at, namely the judge producing a document, that the authorities are dealing with a document that's been stolen, whatever it might be, the raw material document, if I can call that. But what we're dealing with is a more subtle thing. It's the judge generating the same result.
It's the judge.
Legally, because he's the judge. But
he's the judge generating a document in which the information, which is in and of itself not confidential because it can be deduced from a machine on the market. So that there is no shortcut, if I may put it like that. The shortcut only arises where you take something imparted in confidence and misuse it. All the authorities are concerned with such circumstances. Every single case, Saltman and Campbell, Ackroyd and Islington Plastics, Force India, Mars and Technology. The issue was always the distinction between obtaining the information from a legitimate source, Mustard and Dozen, obtaining the information from a legitimate source, in which case it's not confidential as information, or using a document imparted in confidence which contains the same information as a shortcut to obtaining it elsewhere. This is not that case. Those circumstances simply don't exist when you're considering whether information in a judgment should be restricted from public view.
But are they relevant to the decision that has to be taken here?
In my circumstances, no, because you simply don't get off the ground on the argument that there is a breach of confidence, because the information is derivable from the machine and or the redacted judgment. In fact, I'm going to show you, Your Ladyship, that in fact, a mechanical engineer on the evidence can deduce the identity of criterion X simply from reading the judgment in its redacted form. And in those circumstances, in my respectful submission, it is very difficult to see how the identity of criterion X can properly be said to retain any quality of confidence.
Thank you.
Manitou go on in paragraph 19 of their skeleton to rely on the passage in paragraph 220 of my Lord Justice Arnold's judgment in Force India. In my respectful submission, as is made clear by paragraph 222 of the same judgment, the distinction made in that case in relation to accessibility of information concerns the use of the information as a springboard. Relative confidentiality arises when information which is more readily available from a document than through reverse engineering is obtained unlawfully from the document and used as a springboard to future activities. The principle recognises that the springboard is time limited. And this is very important because it is time limited because the information can be derived without the misuse. Relief is therefore limited to the time and effort saved by not having to do so. That this is the correct approach is confirmed, in my respectful submission, by the distinction made at paragraph 222 in Force India, where the information is available by inspection of an article, it is not confidential. It is only the detailed tolerances and specifications found in the drawing which are confidential. If those are used rather than reverse engineered, then there is a shortcut which acts as a springboard. The primary question in such cases is whether the court should grant an injunction to restrain the continued misuse of the information, and if so, for how long. If the misuse is complete, there is a secondary question of how much the wrongdoer should pay for the advantage gained. That is why the accessibility of the information in that context is the guiding principle. because it determines the scope of the injunctive relief or the amount of damages. The principle of relative confidentiality arising from accessibility of information, in our respectful submission, has no application outside that context. Returning to Manitou's argument, in my respectful submission, one can see that it comprises the second half of the complete analysis, where there is information in a document which is used as a shortcut. Namely, that information taken from a document will be in breach of confidence, where 1, the document is confidential and has been misused, and 2, acts as a shortcut. The shortcut alone is not sufficient. The claim only arises when it follows from the misuse. Manitou's argument and the judge's judgment below omit the requirement for misuse and accordingly are in error. The fact that the information is contained in the document as well as being ascertainable by inspection of the machine has no relevance where the question before the court is whether the information in question is in and of itself confidential. If, as here, the only confidentiality relies in the form in which the information is contained, there can be no basis for saying the information itself is confidential. A party who has obtained the documentary form of the information may be restrained for a limited period from using it by a springboard injunction if the document has been imparted in confidence, and he may be paid to pay damages for the value of the shortcut, as in Force India, but he cannot be further restrained from using the information. And can I just interpolate there? The whole of the argument on the other side essentially proceeds on the basis that it is my client who has received the information in confidence and is getting a benefit from having it published. This is nothing to do with my client. This is everything to do with whether or not the information is confidential, whether the judge's reasoning should therefore be set out properly in a public document in compliance with the principle of open justice. My client's position on this is my client has, I may put it crudely, my client has had the benefit of having the information in enabling it to fight the litigation. Its interest is exhausted. What matters now is whether the information should be protected from public view, with the effect that the judge's judgment becomes an assertion rather than a reasoned outcome.
We must assume your client isn't just in an altruistic way putting arguments before the court. You're vigorously contesting
Yes.
the issue on appeal.
So
It's your appeal.
it is my, well, this half is my appeal. Actually, the outcome below was in my client's favour, because the judge decided that even though Criterion X was confidential, his judgment couldn't be understood without its publication. And striking the balance required by Lilly and Icos, he concluded that the need for justice to be done in public overrode the very limited harm that would be, if any harm, that would be done to Manitou by publication of the nature of Criterion X. So, in fact, although I'm opening this appeal, the outcome below was that Criterion X was to be made public. If the information in the misused document is the same as the information which is ascertained by inspection of the machine freely on the market, or from another source, such as a published document or patent application, then there is no claim for breach of confidence by using the information in the document. That is exemplified by the decision in Mustad and Dawson. That being so, there is no basis for concealing the information in this case from the public. That is all the more so where the information is necessary in order to understand the judge's reasoning. Now, can I turn to the application of the law to the facts of this case? Professor Plummer's evidence that the nature of Criterion X can be deduced from the examination and operation of the Manitou machine is unchallenged. I've taken you to that evidence, and I'll just take you to a little bit more of it. Supplementary Bundle tab 7. He sets out in section 2 that with or without access to the redacted form of the Confidentiality, the mechanical engineer would either be told by Confidentiality, paragraph 2.2, that the threshold, the cut-off threshold, is angle dependent but not dependent according to the judgment on a signal representative of the angle of the arm, and that there is no signal representative of the arm angle which by itself directs changes to the threshold. That's the end of paragraph 2.2. So on the basis of the redacted version of the confidential annex, the engineer would know that the system has a threshold that varies with angle, more permissive at low angles than high angles. Also know that it achieves this without a direct measurement of the angle. 2.4, you'd be able to deduce that simply from testing the machine, and you could check that it doesn't use the angle sensor by turning it off or removing it, repeating the testing, so the result would be the same. And he then, in section 3, goes on to explain how, based on that information, the engineer would be able to work out what was being used. And at 3.3, starting at 3.3 and finishing at 3.6, he sets out the reasons why an engineer would necessarily conclude, based on examination of a Manitou machine, that there was only a single candidate for criterion X. See particularly the final sentences of 3.5 and 3.6. On the counter, he explains at 3.7 why the information in and of itself would be of minimal assistance in designing a practical system. As he says, the engineering skill, expertise and effort required to arrive at a practical system which works effectively is much the same, whether one knows what criterion X is or is not. And I can say from my own experience, that evidence doesn't surprise me in the least. Working out how Manitou's machine worked, even with the information in the PPD, was not a straightforward task. What it actually did. There's no response to that evidence. It is unchallenged. Indeed, it is confirmed, at least in part, by the evidence from Mr. Bevan of what he's been told by Mr. Cadou, the designer of the Manitou machine. We look in the previous tab in the supplementary bundle, at paragraph 15 of Mr. Bevan's evidence. We can see what Mr. Cadou told him. Mr. Cadou's the designer. And you will see from that evidence, starting in the third sentence on the 5th line, I understand that it was only after.
Sorry, where are we?
I'm on paragraph 15, page 154 of the supplementary bundle.
Sorry.
That's all right. As usual, I'm not giving the references clearly and distinctly enough.
No, I wasn't listening carefully.
Tab 6, page 154,
Yep,
paragraph 15. Picking it up, if you just cast your eye over the first few lines of the paragraph and pick it up, the important bit starts, I understand that it was only after experimentation and testing. And you'll see what Mr. Cadou told him, as is there spelled out. Even with full knowledge of what he had already designed, knowing not merely the parameters used, but precisely how they were deployed, Mr. Cadou was still unable to determine the further development and changes required without experimentation and testing. It is, we respectfully submit, self-evident that with only a small part of that information, the work and effort required to engineer a practical system will be all the greater. I would point out that there is no direct evidence from Mr. Cadou, and the deductions set out in the final 2 sentences of that paragraph are entirely Mr. Bevan's, not those of Mr. Cadou. Mr. Bevan does not himself profess to have any relevant expertise, and he is, in my submission, not qualified to make those deductions. Further, with the greatest respect to him, they do not follow from the information he's been provided with by Mr. Cadu, whether logically or otherwise. It is apparent from the direct and clear exposition by Professor Plummer that an appropriately skilled engineer would necessarily approach the task of designing a working system in very much the same way and equally effectively, with or without the limited information, which is both non-confidential and required to understand the trial judge's reasons for his conclusions. The evidence is clear in my submission. Whilst the nature of criterion X can be deduced, the observer will not arrive at the specific technique or algorithm used by Manitou. Consequently, the information is of little practical value. We therefore say that the judge below was wrong to conclude that the nature of criterion X is confidential, and that there is therefore no basis upon which its redaction from the judgment is justified. And just to put that beyond doubt, there is a further overriding reason why the identity of criterion X should not be redacted from the judgment annex. In simple terms, it is because the information is already in the public domain for the following reasons. I've shown you the redacted judgment annex.
Is this a ground of appeal?
This is ground 4. I hope. So what we point to is this. It is the passages to which I referred you earlier. Paragraph 25, this is 4 bundle tab 9. I'm in the interim public version. Paragraph 25.
I'm very sorry, but I don't think you quite given me a satisfactory answer to my question. Because if I understand what you're saying just at the moment correctly, you are now seeking to advance an argument to the effect that criterion X is not confidential because you can deduce it not from an inspection of the machines, but from an inspection of the interim public version of the confidential annex.
Yes.
And I'm struggling to find that in your grounds of appeal.
I accept that it is not set out in those terms, but we do rely in the grounds of appeal on what Professor Plummer says an engineer would deduce from the interim public version of the judgment, which he relies on in section 2 of his report. And I'm simply referring to exactly the same material in support of this argument.
Well, with respect, I look at your grounds of appeal at page 30 in the bundle, and ground 2 is an engineer interrogating the Manitou machines.
Yes.
Ground 3 is ascertained from the Manitou machines. Ground 4 is detailed inspection or investigation of a Manitou machine. And ground 5 is reverse engineering of the Manitou machines. So these are all about, and indeed ground 1, information which can be derived from a machine. So all 5 grounds, as I read them at the moment, are about what you get from the machines. I don't see a single ground which is about what you get from the interim public version of the confidential.
You are correct. But it is, I think, important that the court understands what the effect of the judgment is, because the effect of the judgment is quite significant. in that it contains precisely the same information that Professor Plummer identifies in his report as leading to the conclusion that there is only one candidate for criterion X. Because the judgment says in terms that criterion X is used to determine the cut-off threshold. It says in terms that criterion X is based upon measurement of the load on the rear axle. And the only difference between this argument and the arguments I've been advancing is that that piece of information doesn't have to be deduced from the machine. It's set out in the judgment. All the other pieces of information, namely the angle dependence, are set out in both judgment and alternatively by testing the machine. But what you have from the judgment is the signal that is measured, how it is used, that the consequence is angle dependent, and as Professor Plummer says at the ends of paragraphs 3.5 and 3.6, with that information, there is only one candidate, criterion X. So a mechanical engineer reading the judgment will be able to deduce what the information is in any event. Yes, the point that's being made to me is that in the evidence below, Professor Plummer did expressly rely on the redacted version of the judgment as providing background information as one way of deducing what is being done. In those circumstances, in my respectful submission, it is appropriate for me to rely on that on the appeal. We say it can be derived from the judgment and inspection of the machine or inspection of the machine. And in those circumstances, if a mechanical engineer can work it out, it cannot be said that the information is confidential. I would also point out that this places the identity of criterion X into the class of what the Trade Secrets Directive calls readily accessible information identified in Article 2.1a. Thus, criterion X is in our submission neither confidential nor a trade secret. I would also point out Manitou have consented to the publication of the interim version of the Judgment Annex, and they have consented to the publication of the same information by putting their machines on the open market, so that the information may be deduced from them with or without the interim version of the Confidential Judgment Annex. So for all those reasons, we say criterion X is not confidential. Now, that leads to, there's one final issue on my appeal, which is what happens to heads 2 and 4 of the information. That is the acronyms and the other systems, the number of other systems. We've listed them in paragraph 4 of our skeleton, which is at bundle 14, core bundle, tab 14, page 143. I have addressed you on A, and the question additionally arises, what happens to B and C? A number of other subsystems and the acronyms used for them. The only evidence served by Manitou in support of its application to keep all this information confidential was in Mr. Bevan's 7th witness statement, which I've shown you. The evidence, when you read it through, in my respectful submission, apart from the limited information provided by Mr. Cadu in paragraphs 13 and 15, is Mr. Bevan's evaluative assessment of the confidentiality of the information in question. There are no facts. With the greatest respect to Mr. Bevan, that is simply not a sufficient basis for concluding the information is confidential at all. We've pointed out in paragraphs 57 of our skeleton that the nature of the other subsystems is necessarily self-evident from the behaviour of the machine when operated. There is neither an evidence nor an explanation from Manitou why that is not the case. Absent such an explanation, there is simply no basis for these items of information being held to be confidential. Almost more importantly, it is critical that at no stage until after the argument below did Manitou suggest that the additional categories of information required separate consideration from Head 1. They argued that all stood or fell together. There is nothing in their skeleton below to suggest otherwise, and their counsel expressly argued the application on that basis before the judge below.
Well, I haven't been to the transcript, but the impression is that both parties and the judge took the view that dealing with Head 1 was the important topic. He decided that, and nobody then went on to invite him to consider if he was wrong, what his decision would be on the other two.
My learned friend essentially opened it on that basis at page 22 of the transcript. They're all said to be components of the same thing at line 7 on page 22. The transcript is at core 13, I'm told.
Correct.
Four heads of information, all component parts of the same thing. Sorry, line 7 on page 22. Page 93 of the bundle.
Thank you.
And when I was making submissions to the judge at page 51, lines 12 to 20, page 100 of the bundle, the judge put it to me that I was rolling things up.
That's where we get the one lump.
In one lump. And at no point in his reply did my learned friend suggest that was wrong. It is far too late in my respectful submission for Manitou now to resign from that approach. Even were they to be allowed to do so, the absence of evidence in support of the claim to confidentiality is fatal. So those additional heads of information should be determined to stand or fall with criterion X. Now, you mentioned to me the dispute about the amendment to the grounds of appeal. We do not suggest, that's the basis of our appeal. As I understand it, my learned friend and those instructing him have understood that throughout. And it's not suggested that my taking this approach is in any way improper. I understand their concern was that we were going to seek to raise on his appeal the additional point that these items of information should also be disclosed on the individually on the basis that they were confidential but were necessary to understand the judgment. I am not raising that case. It's only on my appeal that I raise this point. I therefore think the satellite dispute goes away. My submissions on my appeal are that for the reasons I've outlined, criterion X is not confidential, and that the remaining two heads of information stand or fall with it on the basis on which the case has been argued, and in any event, on the basis that there is no evidence from Manitou in support of independent confidentiality of those items of information. Unless your lordships and your ladyship have any questions, those are my submissions.
Or unless you get any information from behind you.
All right, I'm sorry. Pointed out to me in answer to my Lord Justice Arnold's question, in paragraph 2 of the grounds of appeal, we refer to taking into account the information acknowledged by Manitou to be non-confidential, which includes the information in the interim redacted version of the judgment annex, because they acknowledge that is not confidential.
Well,
yes. Yes. Pointed out to me that it was because of the satellite dispute has given rise to an issue in relation to heads 2 and 4, the information. In the PPD, they are coloured green because we were trying to agree an order. Our position is that they should be unredacted, and therefore, effectively, it should be treated as coloured blue. That is the satellite dispute, essentially. But we can deal with that as and when your lordships and ladyship have decided what the outcome of the appeal is, and then we can determine how that affects what is to be redacted or not redacted. I'm just pointing out to you that some of the green colouring in the PPD is in fact colouring that we say should be blue. But that relates to the 2 subsidiary heads of information. I'm sorry about this.
But I'm reassured by you saying we needn't be concerned with the detail of that at the moment.
As far as I can see, you need not be concerned with the detail of that. That's a matter for my learned friend and me to sort out.
It'll become clear, you anticipate, when we decide the main issue.
Once you've decided the main issue, what is done to the redactions will follow. And no doubt, in the usual time-honoured fashion, if we can't agree them, we'll come and ask you, but I would hope that won't be necessary.
Thank you.
Is there anything else?
No, thank you very much, Mr.
Thank
Sylvie.
you.
Yes, Mr. Nicholson.
My lords and my lady, subject to any thoughts the court may have, I intend to take the same approach that we've taken in our skeleton, namely to address my learned friend's appeal, then my respondent's notice, and then open my own appeal.
Yes.
Hopefully, my lords and my lady have also received my supplemental skeleton addressing the trade secrets material.
We have, yes. Very grateful.
As the court will have seen, the points in that supplemental skeleton are relevant or potentially relevant to both appeals, and I was intending to put the points up separately in the context of each appeal. JCB's appeal is to say that the judge was wrong to hold that head 1 of Manitou's confidential information, the so-called criterion X, is confidential. Now, I should mention that whilst the parties have focused their submissions on the annex to the judgment, as we did below, there is a significant knock-on consequence to the PPD itself, all of the expert evidence, and the skeletons and so on from trial. Clearly, if something is published in the judgment, it can't properly be maintained as confidential in the underlying document. I was very surprised to hear my learned friend say that his interest in all of this has been exhausted, and that he's here effectively as a knight on a white charger seeking to protect open justice. In the course of this case, when the PPD was originally filed, that's my client's document setting out how its machines work. A very unusual application was made that came on before Mr. Caddick, Queen's Counsel as he then was, sitting as a deputy judge of the Patents Court, seeking a determination that the PPD as a whole wasn't confidential, and in the alternative, seeking a release of that document to allow it to be used in foreign proceedings, because there are parallel proceedings between the parties in France and in Italy. That application was rejected. The document wasn't determined to be confidential. The court determined that it was too early in the proceedings to deal with that, but it would be treated as confidential pro tem. But the law was looked at on the use of disclosure from English proceedings for foreign proceedings, and my learned friend's application was found wanting. He had permission to appeal to this court. That permission was never exercised. Throughout these proceedings, there has been a continued and ongoing attempt to take the disclosure from these proceedings to foreign tribunals, where he has sought to rely on experiments to show how my client's machines worked to a greater or lesser extent. Insofar as my learned friend is impressing upon the court that his interests have been exhausted, We do not accept that. We say that what's going on here is an attempt to get descriptions endorsed by my client as to how its machines work so that they can be used in other proceedings. Now, we can pick up the main points on...
Well, that comes as, in one sense, news, and in another sense, no surprise whatsoever, because that's a common scenario in these types of disputes. But so what?
My lord is absolutely right as to so what. I had no intention of telling my lord and my lady about it until my learned friend chose to press upon you in an equally so what manner that he had no interest in this, and this was all in the interest of the proper administration of justice in the normal way. As the court is now aware, there is a very live dispute between the parties as to this information. We have different procedures in different jurisdictions, different ways of proceeding. In the English courts, a defendant pulled into patent litigation is required to open up their internal private information and make it available so that the court can really understand what's going on. In foreign proceedings, they operate differently. As was decided by Mr. Caddick below, it's not for this court in this jurisdiction to consider that foreign jurisdictions would be better if they did have a disclosure process.
Still less to advise them as to how to comply with the Intellectual Property Protection Directive.
My Lord Justice Arnold is right. So it is a so what, but insofar as it matters, it isn't as straightforward as my learned friend suggests. Now, picking up in on my answer to my learned friend's appeal in my main skeleton at page 3. As we've pointed out, despite the purported 5 separate grounds of appeal, JCB's complaint is primarily a simple dispute as to the law. The principal difference between us is that my learned friends contend that under the English common law, information ceases to have the necessary quality of confidence if it can be reverse engineered from a product which has been made available to the public. As my learned friends put it in paragraph 36 of their main skeleton, the law is clear that all information that can be derived in this case by a typical engineer from an inspection of a Manitou machine which has been freely placed on the market is not confidential. Now, my client's position, as accepted by the judge, was that the merely being reverse engineerable is not sufficient to destroy all confidence in documents which set out the information in a clear form. Those documents can still have the necessary quality of confidence insofar as they would provide a recipient with a shortcut to avoid having to expend the skill and labour required to reverse engineer the product itself. Now, the present case is not about JCB actually having reverse engineered Manitou's products. It's about them having free access to information which avoids the need for them to undertake the reverse engineering exercise at all. And as we made clear in our skeleton and below to the judge, Manitou does not dispute that it would be legitimate for JCB to reverse engineer Manitou's products that were freely on the market. If someone outside of the Confidentiality Club, who already knows how they work, did so, and did determine criterion X by that process, then Manitou could make no complaint about JCB's subsequent use of the information. And here I do differ very much from the way my learned friend drew your lordships and your ladyship's attention to Coco and Clark, focusing on the issue of the final essential step of a breach of confidence case is misuse of confidential information. That is absolutely so. But this hearing, or the hearing below in this appeal, is not about misuse of confidential information. This case is about whether or not the information is confidential and whether the court should therefore protect it so that any subsequent use of the information would still be a misuse. When one's dealing with the protection of confidential information, there is no contention generally that my learned friends are going to take the information and use it unless it's declared not to be confidential or unless it's public. And of course, once it's public, it's not confidential and he's free to use it. So it's entirely wrong to say my case doesn't get off the ground unless there's a misuse, because we're in a protection case. But it's equally wrong for my learned friend to say that because steps 1 and 2 of Coco and Clark, or the particular one, the quality of confidence, is frequently discussed in a misuse of confidential information case. Is the information confidential? Was it misused? Somehow or another, those steps change or don't become relevant when one's saying, is there confidential information and should it be protected? Now, in the present case, reverse engineering is not what JCB has done. What they're seeking to do is to have free access to my client's product and process description and all the documents deriving from that PPD without having to undertake the reverse engineering work, which its expert contends would reveal the core of how my client's machines work. Now, as my Lord Justice Arnold, I know, will be familiar, but for the benefit of us all, a PPD is a document prepared for the purpose of patent litigation in lieu of disclosure. Its role is to explain to the court and the patentee in a factual and non-tendentious way precisely how the defendant's machines operate to enable the question of infringement or not of the patentee's patent to be determined at trial. And it's convenient to point out at this stage that JCB has made and continues to make on this appeal criticisms of Manitou's PPD. And whilst the accuracy of the PPD has nothing to do with the current appeal, it's only right to point out the judge held at trial that JCB had failed to put a proper case that the PPD was inaccurate in any way, such that the judge considered himself obliged to assume it was accurate, as he recorded in paragraph 165 of the judgment. Nor did the judge find that he didn't have the information necessary to determine infringement. We respectfully say in the circumstances it's not open to my learned friend to continue to make unfounded allegations which are contrary to the facts found by the court and in respect of which there is no appeal. JCB has also made reference in its reply skeleton to the PPD being supplemented on several occasions. The innuendo being that my clients have kept having to change their story. That also would be untrue. The case has run for something like 5 years up to the first instance trial, and during which time the patents in issue and the products in issue changed significantly. It was these changes in the scope of the case that necessitated the inevitable supplementing of the PPD.
Now, if I remember the dates correctly, configuration C only kicked in 2019.
Your Lordship is almost certainly right.
That's after.
It was late in the day.
Yes.
There were actually 2 individual actions, and configuration C came in very late when my learned friend introduced yet another patent, realising that his case was likely to fail, no doubt, on the patents and the products he already had in. So he came forward with another patent, and my client's response to that was what we call in the art a design around. We look at what the patent requires and say, we think we're not doing that, but if we are, we're going to change it so that come the outcome of the trial, we won't be caught by an injunction, which is indeed what happened in the present case. So we say this isn't a case where the defendant couldn't be trusted to give an accurate, complete description. Turning now to the law. In our skeleton, we argued the point, as we did below, on the basis of Marsden Technology and Force India. And my Lord Justice Arnold has helpfully drawn the party's attention to the first instance case of Kerry, which was a decision of Mr. Justice Newey, as he then was. And we've picked that up in our supplemental skeleton, paragraphs 15 and 16. I don't think we especially need to go to it, but that's where it is for your, my lord and my lady's note. Now, as we see it, there's nothing particularly special about the Kerry case, but it may be of assistance in that Mr. Justice Newey summarises a wider number of cases going all the way back to Saltman in 1948, all of which consistently explain the relevant common law on confidential information in materially the same way. And perhaps we can turn Kerry up. It's in the authorities bundle at tab 15. And we can pick up the relevant start at page 386, entitled Quality of Confidence. And this goes to that important aspect of Coco and Clark. Does the information have the necessary quality of confidence before we can go on to a question in a breach of confidence case of any misuse? Now, Mr. Justice Newey picks up Saltman at paragraph 60, explaining that it is perfectly possible to have a confidential document, be it a formula, a plan, a sketch, or something of that kind, which is the result of work done by the maker upon materials which may be available for the use of anybody. But what makes it confidential is the fact that the maker of the document has used his brain and thus produced a result which can only be produced by somebody who goes through the same process. Now here, the master of the rolls sitting in this court was contemplating the formulation of a document by reverse engineering publicly available materials. But the key point that the court is drawing here is a distinction as to the form of the information. The resultant plan or sketch doesn't cease to be confidential because implicitly the same information could be reverse engineered by others. Picking up Saltman again at paragraph 63 of Kerry, the master of the rolls explains that what the defendant to a breach of confidence case did wrong was to dispense in certain material dispense in certain material respects with the process which has been gone through in compiling these drawings, and thereby save themselves a great deal of labour and calculations and careful draftsmanship. Lord Green goes on to explain rightly that no doubt if the defendants had taken the finished article, namely the leather punch, which they might have bought in a shop, and given it to an expert draftsman, that draftsman could have produced the necessary drawings for the manufacture of the machine tools required for making that particular article. But Lord Green makes clear in the remainder of the quote, not taking the course of reverse engineering, but instead misappropriating the drawings done by another, furnished the defendants with the same information that saved themselves that trouble, and that amounted to a breach of confidence. In paragraph 65, in paragraph, I think it's 64, Mr. Justice Havers, at first instance in 1962 in Ackroyd's, again distinguishes between putting a manufactured product on the market, the underlying information about the product, holding that the marketing would not make the information to the public available if the work would have to be done upon the product to make the information available. At 66, Mr. Justice Newey quotes the same paragraph of Force India that we relied upon below, and in paragraph 17 of our main skeleton, and to which the judge referred at paragraph 24 of the judgment, again drawing a distinction between information which can readily be ascertained from inspection of examples of the article which have been sold, and information which cannot readily be ascertained from inspection, but only by a process of reverse engineering. Noting that the defendant used drawings as a shortcut rather than taking the time and effort to reverse engineer, and that would amount to a wrongdoing. We then get the conclusion in the light of all of these cases over the last 70 or so years, at paragraph 67. In the circumstances, it seems to me that the fact that information could be obtained by reverse engineering will not itself prevent it from being regarded as confidential, if at least the reverse engineering would involve a significant amount of work. Now, Mr. Justice Newey then continued and put it in a slightly different way based on the submissions before him, that the information will not be confidential if it could be arrived at without any special labours. And we agree. All of this case law is to the same effect. JCB's contention that the law is clear that all information can be derived by a typical engineer from a machine which has been freely placed on the market is not confidential, is simply wrong in law. If significant work or brain power is required to obtain that information, anything which amounts to an appreciable shortcut of that process by accessing documents which avoid the need for that process would amount to a breach of confidence. Or put another way, as is appropriate in this case because it's a protection case, those shortcut documents continue to have the necessary quality confidence. And that is precisely what the judge held in the judgment at paragraph 25. An owner of any machine is entitled to find out how it works via as much detailed inspection or reverse engineering as they please. Whatever information is thereby discovered will not have been obtained in breach of confidence. But exactly the same information may exist in a document, and another party's act of using or disclosing the information derived from the document will be a breach of confidence because such an act permits the exploitation of the information by means of an unlawful shortcut. In other words, without having to bother with the work of dismantling or reverse engineering. Looked at another way, the information as recorded in the document retains its quality of confidence because it is in a form which makes unlawful shortcut possible. Now, we also relied before the judge...
Is there just obviously coming to these issues fresh as it were, is there a further element? With reverse engineering, there comes a time when the reverse engineer thinks, well, that must be what they're doing. Publishing the document that originates from the primary source not only shows what's happening, but confirms that's what is happening. So does that add a quality to
there is
information?
Absolutely a further degree of confidentiality in that endorsement as to the source of the information. I mean, one can see it, I say hypothetically in this case. My learned friend no doubt would think himself in a better position to go before the court with the court in another jurisdiction with the PPD from these proceedings produced by Manitou and signed as being true to the best of
that's
knowledge
the thought
and
I had in mind. Yes.
than going forward with his own experiments, saying we've done these experiments and we think this is how the machines work, and then, as inevitably happens when someone puts experiments up, you end up with a healthy debate about whether or not the experiments were done.
I'm reminded of Mr. Silverleaf. That's when Mr. Silverleaf came up with Sherlock Holmes. That if you reverse engineer this machine, you only come down to one option for what criterion X must be. There we are.
Well, quite, and I tread carefully because I haven't challenged the evidence of Professor Potter, but one always has to be cautious about evidence where somebody, particularly when they already know the answer, ends up concluding that this is the only way to go. It's something we're familiar with the hindsight problem in a normal pattern obviousness.
Very hard to avoid, isn't it?
That once you know the answer, lo and behold, all roads lead to the same place. But yes, your lordship is absolutely right. There is an extra element when one takes the authorship of the document into account.
Thank you.
I was just saying that we also relied before the judge on this appeal on Mars, the relevant parts of which we've quoted paragraph 15 of our skeleton. This doesn't appear to have been cited to Mr. Justice Newey. We respectfully say that Mars is very much to the same effect as the other authorities, save that Mr. Justice Jacob, as he then was, helpfully introduces the concept of the form in which the information is available. The information derivable from a real product may well be the same as the information derivable from a document, but the important factor is that the form is different, such that the accessibility is different. As the court will appreciate, to access the information in a document, one only has to read it. That's a significant shortcut to accessing the same information from analysing a product, which requires work and deduction to be expended to obtain it. Now, I propose to come back to the law having regard to trade secrets in a moment, but we did not put the case on that way before the judge. So if I may, I'll address the judge's assessment against...
You say that, and it's something I find deeply mystifying, because I fully accept that the expression trade secrets wasn't used by either party before the judge, and hence it wasn't used before the judge, by the judge himself. You look at the index on the transcript, you can see that. However, what you are actually talking about must have been trade secrets. It cannot have been anything else. Not least because, as everybody knows, the foundation of the jurisprudence in this entire area is Scott and Scott, which recognised 3 exceptions to the open justice principle, of which the third was trade secrets. Moreover, there is no other way to describe the variety of confidential information that your clients are seeking to protect. So even though nobody called it trade secrets, that was in fact what you were talking about. Is that not correct?
Just say yes.
My lord is absolutely right. My lord is absolutely right. And with 20/20 hindsight and the guiding hand of the Court of Appeal, one sits and says, why did we not say trade secrets? My learned friend didn't say it, I didn't say it, the judge, an experienced judge in this area, didn't say it. And we all proceeded on the basis of the common law. I'm only cautious on my part because I don't want to be accused of running a different case before this court on the basis that what I have is a trade secret.
To be sure, but as I'm sure you appreciate, there's 2 different questions. One is effectively a terminological question. Because you talk about the common law, I'd rather refer to equity. But the point is the same, namely that well before the Trade Secrets Directive, English law protected trade secrets, including within this particular context, as we see from Scott and Scott. And the term trade secrets is expressly and explicitly used by 3 out of 5 of their lordships. It's not like it's a new term of art. That's the point I was making a moment ago. So that's the terminological question. Then you get into the substantive legal question, which is, does the advent of the Trade Secrets Directive make any difference, either positively or negatively, with regard to the protection previously afforded by English law?
My lord is absolutely right, and those are exactly the topics I intended to cover. If I may seek your indulgence, if I go through the case as dealt with by the judge and then approach trade secrets as on exactly the topics that my Lord Justice Arnold has drawn to my attention, would that be acceptable?
Yes.
I'm grateful. So before the judge, on this confidentiality dispute, JCB had filed a further expert report on its trial expert, Professor Plummer, as my learned friend has already referred to. Just out of an abundance of caution, I should mention that some parts of Professor Plummer's third report might be said to have relevance to the appeals on the substantive judgment, which is due to be heard by this court in January. And as a condition for admitting the late evidence, which we didn't have the opportunity to cross-examine on, JCB agreed that the new report was solely for the purposes of the confidentiality dispute, and that's expressly recorded in paragraph 6 of the court's order. Now, as far as we're concerned, that order continues, and by continuing to refer to Professor Plummer's third report, we are not consenting to any wider use of that when it comes to the substantive appeal.
Right, well, you've made that clear.
I'm grateful. Now, with that proviso in place, my client does not and did not seek to challenge Professor Plummer's evidence. And it's worth looking at it. It's in supplemental tab 7. As my lords and my lady have been told, the conclusion of Professor Plummer's evidence is that an engineer seeking to work out how Manitou's machines were operating would be unlikely to arrive at the precise approach used by Manitou. That's paragraph 3.6. But Professor Plummer also says that by a process of analysing the public parts of the court's judgment, that's dealt with in sections 2.1 to 2.3, either alone or in combination with undertaking examination and testing of the machine, the engineer would be able to determine that Manitou's machines achieve the same purpose as JCB's patent. Now, he puts that on the basis to say that they have a threshold that varies with angle, that is more permissive at low angles than at high angles. They were then also determined, and Professor Plummer expressly makes this point in paragraph 2.4, that because the engineer would know there was no infringement, that this must be achieved without a direct measurement of the angle of the arm. And that comes out, yes, in 2.4. Now, the testing or experiments that Professor Plummer has in mind include loading up the machine with different loads and lowering the arm to determine what Professor Plummer chooses to call the stability cutoff threshold, and then repeating the tests, having either electronically or mechanically removed the angle sensor. But even this testing does not get JCB home, even as far as head 1 and the use of criterion X. Professor Plummer therefore starts a new section in his report at section 3 at the bottom of 164, where he records at 3.1 that JCB solicitors have asked him to consider the ways in which a competent engineer could implement such a system without using JCB's invention. And there then follows what the judge called Professor Plummer's process of elimination, by which he concludes that the competent engineer would appreciate the possibility of using criterion X. It involves, for example, at paragraph 3.4, which I won't read out because it's confidential, that a process of elimination requires further deduction based on a detailed inspection of Manitou's machine. At paragraph 3.6, Professor Plummer then records that there are significant engineering issues with arriving at a practical application of this type of approach, and goes on to say in the same paragraph, thus from from the information in the non-confidential versions of the judgment annex and inspecting the Manitou machine, the engineer is unlikely to arrive at the precise approach used. He or she would, however, appreciate criterion X. And then further concludes a paragraph 3.7, although not in any way a matter for him, that this fact cannot be considered confidential once the non-confidential version of the judgment annex has been published. And as I hope we've made clear, we don't agree with some of what Professor Plummer divines from the judgment, and it of course has to be remembered that he already knows the secret answer because he was JCB's trial expert and had full access to all of the confidential materials. But as I hope I have made clear, we didn't challenge the evidence because we didn't need to do so. What matters from all of this evidence is that it is quite clear that a significant amount of work is required to reach even the partial understanding of Manitou's machine to deduce criterion X. It is a detailed analysis of either the public parts of the court's judgment or detailed inspection and experimentation of a Manitou machine, coupled with the mental process of skilled engineering in engineering deduction and subsequent elimination. Now, as the judge found as a matter of fact, he was clearly entitled to find on JCB's uncontested evidence. At paragraph 28, Professor Plummer conceded that only a detailed inspection of Manitou machines would allow the engineer to identify this criteria, referred to in argument as criterion X. A competitor reading the unredacted annex would obtain the information without having to conduct a detailed investigation or go through Professor Plummer's process of elimination. Having held that under the common law, reverse engineerability is not good enough, and that documents which provide a shortcut continue to retain the necessary quality of confidence, and the judge found that in paragraph 25, the judge was wholly entitled to reach the decision of paragraph 28 that the unredacted annex represented such a shortcut to Professor Plummer's detailed investigation or process of elimination that the material in the unredacted annex retained its quality of confidence. And there's absolutely nothing wrong with the judge's decision when approached in that way on the common law.
Can I ask you this question? Let's assume that the submission you've just made is, after due consideration, accepted. What is the consequence? Because at the moment it seems to me the consequence is that criterion X has a limited degree of confidentiality, in the sense that, as you argue, if this analysis is accepted, the use of the document provides a shortcut. And as you submitted earlier, and I think to some extent this is common ground, one way of looking at this question is by reference to the remedies that hypothetically would be granted upon a claim for misuse of the information, albeit that is, of course, not the scenario in which we are concerned. Would you accept that, on the basis of the evidence, the conclusion which should be drawn is that in that hypothetical scenario, the injunction would endure for a period of weeks rather than months or years?
Two aspects to it. The first one has already been identified by my Lord Justice McFarlane, which is that there is, even in those circumstances, there is a difference between what can be reverse engineered and something endorsed by Manitou itself. The reverse engineering process can never reach a position of endorsed. Secondly, one has to be a little bit careful with documents that have been produced endorsed by Manitou for the purpose of certain litigation proceedings, because they need to be accurate for the purpose of the patents that were raised in these proceedings, and not necessarily generally. So one has to be a little bit careful insofar as the information is used in a foreign jurisdiction to sue Manitou for on a different patent, and JCB has a big pile of patents, whether or not there were difficulties caused by releasing the PPD as such, as opposed to Professor Plummer conducting his exercise of reverse engineering. And that then does bring me to my second major point on this, which is I hope I've made clear that although we accept for the purpose of this argument that Professor Plummer's evidence is unchallenged, we don't accept it's right, and we raise real concerns about the exercise being conducted by somebody who already knows the secret. The scenario that one would normally have is that somebody utterly independent who hadn't been exposed to the secret answer would be sent off to do the reverse engineering process without being steered by a legal team and already knowing where the answer is. And whatever they derive would then come into the public domain.
Well, I've got two problems with that. First of all, you can't with one breath say that you don't challenge Professor Plummer and simultaneously say he's wrong. The fact of the matter is that his evidence is unchallenged in this court, and we have to proceed on that basis, do we not? But then secondly, let's come back to the question that I was asking, which is, in these types of cases, you always have to measure the extent of the advantage, and that then leads into the relief that's granted. So you see that in the Kerry case, for example, where the judge measured the extent of the advantage as best he could on the evidence before him, and he granted an injunction which lasted a year, roughly speaking. And I don't think it was exactly a year, but in rough terms. So that was the extent of the head start that they got by misusing the confidential information. He did not grant a perpetual injunction.
My Lord, and this is the difference between a protection case and a misuse case, where the safeguarding is approached in a different manner. In a breach case, as your Lordship identifies, a springboard or time-limited injunction is very often the appropriate remedy. They've done it, they would have done it, they were doing it anyway, how much time have they saved? There goes the springboard injunction for that period of time. In a protection case, and in the Trade Secrets Directive when we come to it, the approach taken is different. The approach taken is that the order is made subject to the information going into the public domain. That means that if JCB, for example, wants to undertake the burden of having an independent party conduct the experiments and end up with a document which contains all of the confidential information, and they do it quickly, they will say it's now in the public domain, I'm entitled to reverse engineer the machine and to publish the results, and there we go, that's fine. The injunction against the misuse of the confidential information will naturally cease. What one doesn't normally do is say, how long might it take somebody to, what are the circumstances where this might come into the public domain? How quickly could I get there? And then time limit the protection. All of the protection cases say, unless and until the information becomes public.
Well, I can understand that as a legal proposition. What I'm slightly struggling with is how that relates to the present case, because so far as I can see, there's been no discussion hitherto at any stage about a public domain proviso.
Your Lordship is right that I don't think it's ever been expressly asked for. I would say it was implicit in the normal course, because that's how it works. There isn't misuse if you've got publicly available access. But insofar as the matter having come to everyone's attention, it's appropriate for there to be a publication proviso, then I can't object to making express that which I say is implicit.
All right, thank you.
My lords, my lady, that may be a convenient moment to move on to trade secrets. We dealt with this at length in our supplemental skeleton, borrowing heavily from the commentary of my Lord Justice Arnold, either from his joint article with Professor Appellant or the judgment of this court in Selgar. Starting at paragraph 5 of our supplemental skeleton, we note that the Trade Secrets Directive does not sweep away the common law. What it does is create a minimum requirement for the protection of trade secrets across the European Union. What my Lord Justice Arnold calls a flaw. But it also modifies the common law insofar as the common law does not already have sufficient safeguards expected by the European Union. Something that my Lord Justice Arnold refers to as a ceiling. So, for example, the Trade Secrets Directive provides exceptions or protections for whistleblowers to the extent that, so that a whistleblower doesn't find him or herself in breach of confidence. And to the extent that the common law didn't provide sufficient exceptions, it's now required to yield to the directive, and that's the ceiling. Now, we've explained in paragraph 7 of our supplementary skeleton that we don't believe that any of the exceptions that arise under the directive are material to our application of the common law in the present case. We do, however, draw attention to Article 3.1b of the Directive, which is in the authorities bundle at tab 11. Although we've quoted it in...
Do we need more than your...
No, I don't think you do, my lord. We've quoted it in paragraph 7, and this is concerning reverse engineering. Now, on its face, this provides a clear exception to acquiring confidential information by reverse engineering, which we note in passing is observation, study, disassembly, or testing of a product or object. Now, importantly, what we see in the directive is the exception does not arise to rob a trade secret of its value merely because reverse engineering is possible, i.e. reverse engineerability, as I was referring to it earlier. What the provision does is to provide an exception for someone who acquires the information through reverse engineering. Now, we say that's entirely consistent with the distinction we have been addressing under the English common law. There's no prohibition on reverse engineering, but mere reverse engineerability does not destroy confidential information in a shortcut document. Now, importantly, if the common law was as JCB contends, the UK's common law would be below the floor required by the directive. The directive requires various protections for trade secrets, and the UK would not be providing those protections in circumstances where the information had been made available to the public because it was reverse engineerable. Because reverse engineerable does not destroy a trade secret under the directive. The consequence being that the UK's common law would be providing less than the minimum harmonised level of protection. Now, the further aspect that we take is that Professor Appellant and my Lord Justice Arnold rightly point out in their article that the UK's legislature did not directly implement Article 3. No doubt, on the basis, so Article 3 includes the reverse engineering clause, no doubt on the basis that the legislature considered the English common law on reverse engineering not to be materially different to that required by the Directive. Now, we don't disagree with my Lord Justice Arnold that things may have been clearer if the article had been directly implemented. So many commentators have said on so many occasions when the UK seeks to implement directives that life would be so much easier if we just implemented the directive rather than rewrote it, changed the wording, missed out clauses that we didn't think was necessary. And no doubt this may well be one of those occasions. But that doesn't concern us here, though. What matters is that the proposition as to the law which JCB contends for would be incompatible with the directive, and clearly, therefore, incompatible with the legislature's intention for the regulation, and must therefore be wrong. Now, I will come on to look at the protective aspects on trade secrets in the context of litigation in a moment, but to pick up on a point that my Lord Justice Arnold was making earlier, what we will see with respect to those is that they do not give time-limited protection in the case of reverse engineerability. They give an absolute protection until the material is put in the public domain. Now, going back to finalise my submissions on my learned friend's grounds of appeal, grounds 1 to 4, we've gone through the starting at paragraph 26 of our main skeleton. Yes, sorry, I picked up on page 7 of our skeleton. Grounds 1 to 4, as far as we can see, in essence, grounds 1 to 4 all appear to be slightly different ways of putting the same legal point. Is reverse engineerability enough to destroy all confidence in the information? Indeed, JCB deal with ground 1, which is clearly the legal point, and then wrap up grounds 2 to 4 without adding anything material in just 3 paragraphs of their main skeleton. And for the reasons we've explained in respect of the common law, but equally supported by the Trade Secrets Directive and regulation, we say JCB's contention is simply wrong. And we can see nothing in the proposed amended grounds which would make any difference whatsoever to grounds 1 to 4. Ground 5 is slightly different, and we pick this up on page 8 at little f. Although the point wasn't argued below, and with respect to my learned friend, one struggles to get it out of the grounds against which permission was granted. JCB's point here seems to be that if the judge was at least partly right about the law, he was wrong to hold that the amount of effort and deduction involved in Professor Plummer's detailed investigation and process of elimination was enough to amount to reverse engineering. We respectfully say there are a number of problems with taking the point at this time and in this way. Firstly, no submissions were made to the judge about what the appropriate level of reverse engineering might be. Second, it's quite clear that whatever Professor Plummer had in mind, it wouldn't be a trivial amount of work. And finally, as we saw in the context of the law, reverse engineering is only one of the labels which have variously been used by the courts to refer to the effort which is being shortcutted. One doesn't get to the appropriate standard by asking what amounts to reverse engineering. The material question is really, is there a significant shortcut, as to which the judge was thoroughly entitled on the unchallenged evidence to conclude that there was. it really ought not to be open to JCB to seek to ask this court to reach a different evaluation of the evidence without contending that no reasonable tribunal could have concluded that the shortcut was sufficient for confidentiality to remain. And as we look across to the Trade Secrets Directive, and Regulation 3, insofar as one takes guidance from the way that the wording is used, reverse engineering in observation, study, disassembly or testing of a product or object that has been made available to the public, or that is lawfully in the possession of the acquirer of the information who is free from any legally valid duty to limit the acquisition of the trade secret. The bar is set really very low, not in a scenario whereby it could reasonably be said that what Professor Plummer is talking about doesn't amount to observation, study, disassembly or testing of a product. The final point that we picked up in our skeleton, which is worth just spending a quick moment on, paragraph 27. JCB seeks to trivialise the reverse engineering effort involved by pointing to Professor Plummer's evidence that to get from criterion X to a commercial machine would require a significant amount of engineering effort. Now we say that's no doubt the case, but the law is about the shortcut and not the size of the entire commercialisation process. Moreover, JCB fails to appreciate that substantially the same significant amount of effort would be required to put JCB's patent into effect. There's almost always a massive engineering project lying between the enabling concept and the commercial realisation. And we respectfully say it makes no sense to say that JCB's patent is a valuable monopoly, but that Manitou's equivalent monopoly protected by confidentiality would not be afforded the same or similar value or respect by those skilled in the art.
Well, you may not want to answer this question because it would give away too much. But are you able to tell us anything about the extent to which your clients have applied for patent protection? I mean, to some extent, that information, of course, will become public at some point anyway, if applications have been filed which are pursued.
My Lord, may I just take instructions on that?
Sure.
My Lord, I don't find myself in a position to answer that question within the scope of my instructions.
Yeah, all right, fair enough.
Finally, then I pick up, I will see if I can resolve that situation over the short adjournment, my Lord, and if I can, I will do. My Lord, I do have a respondent's notice, which is paragraph 30 of my main skeleton. I can take this quite quickly because it only arises insofar as JCB's appeal succeeds on head 1, that criterion X isn't confidential. If it isn't confidential, then the question arises as to what happens to heads 2 and 4, which the judge also held to be confidential. Just to be clear about this, so we all know exactly what we're talking about, my client has long accepted that if criteria X isn't confidential and is to be published regardless of its confidentiality, no meaningful confidentiality can remain in the acronym for that subsystem, which is one of the parts of the head 4 confidential information. And for my Lord and my Lady's reference, that's the first acronym in paragraph 4C of my learned friend's skeleton. Probably ought to turn that up just to make sure. we all know what we're talking about. I have my learned friend's skeleton on page 2.
There are two.
There are two an
There is
acronym.
the first one you say if criterion X is no longer confidential,
Then that goes.
that goes.
Long set. So the debate is really about the second head. The second thing, whilst we've got this open, that is worth me pointing out, is that I don't accept my learned friend's description for sub B, that the fact that the configuration system is made up of a particular number of subsystems. It goes a lot further than that. It's how many subsystems there are, what each of them does, and their interaction between each other, so that you can see the system as a whole. So it's very easy to trivialise it, as my learned friends perhaps do, by saying, oh, it's just a number. But it's more than that. It's what does our overall system look like. And then head 3.
Can you just help me on that? Because it wasn't clear to me how much of this, once you get beyond the numbers and the acronyms, how much of that is actually in the confidential annex? I appreciate there's more in the PPD.
Well, I was going to come on to exactly that point if my learned friend was going to run the appeal that I feared he was going to run, which was that 2 and 4 should be published as well. Because in fact, when you look at the confidential annex, there is precious little reliance on heads 2 and 4 at all. And it rather shows that what my learned friend is interested in here is having 2 and 4 declared to be non-confidential so that they can be included in the judgment. The reason that my learned friend wants 2 and 4 made or declared non-confidential is so that he can find them in the PPD and find them in the expert reports and find them in other materials where no doubt he feels they can be put to some use. Yes, your lordship is right. We don't think 2 in particular, but 2 and 4 materially is needed to understand the judgment. And certainly the judge didn't hold that 2 and 4 mattered. We'll come on to look at it.
But the fact that there was no debate about them indicates that, in fact, the focus was all
on one.
criteria X.
Because as we'll come on to look on my appeal, what the judge was concerned about was criterion X is something he really felt he needed to share with the reader if the reader was to understand a particular part of his judgment. We'll come on to that in due course. So just on the confidentiality of 2 and 4, the problem for JCB, which arose long before there was any issue of skeletons being exchanged or arguments before the judge or the way in which matters were dealt with at the hearing, is that its evidence only supports reverse engineering of head 1. There is no evidence from Professor Plummer that the number and type and interaction of subsystems could be determined from any form of reverse engineering, nor, unsurprisingly, is there anything about acronyms, which have never been suggested could ever be reverse engineered from Manitou's products as such. Indeed, as we've looked at, Professor Plummer's evidence in his paragraph 3.6 is that the engineer is unlikely to arrive at the precise approach used by Manitou before going on to say that you would get to criterion X. Now, as such, whether JCB is right because of its view of the law on reverse engineerability, or whether it's right that the burden on reverse engineering was placed too high, or on both, JCB has nothing by which to argue its case in respect of heads 2 and 4. And that was also the position before the judge, which is no doubt in part why JCB proposed that everything stood or fell on head 1. Now, as we explained in oral submissions, JCB's reverse engineering did not cover heads 2 and 4. As we actually put it, the evidence does not get off the ground.
So this seems to be a dispute about the burden of proof. Because as I understand Mr. Silverley's argument, he says that the burden is on you to show that heads 2 and 4 are confidential. So that's his argument.
And the difficulty for my learned friend here is I did have evidence, and it was shown to your lordships earlier. It's Mr. Bevan's witness statement, and he criticised it for being hearsay evidence from the designer, Mr. Cadu, but nevertheless it was evidence that was before the court. It's in the supplemental bundle.
It's an unusual way of presenting evidence, isn't it?
My lord, a year down the line, one can look at things in different ways. It was the
It
evidence.
gives rise, we were taken to a paragraph and Mr. Silverleaf said the final two sentences are the author's conclusions and not Mr. Carey, if I remember the name correctly. It's ambiguous. It may be a summary, further summary of what Mr. Carey, but to have the evidence coming to the court through the filter of a statement by a solicitor really just raises these sorts of difficulties, doesn't it?
Well, my lord, it does raise the difficulties, and it's easy with 2020 hindsight to look at matters differently. You know, as arose in these matters, there are a number of disputes to be dealt with, a number of issues going on. A huge amount of work was being done at the time trying to redact all of the underlying documents. Rightly or wrongly,
this is obviously not a field that I have much experience.
But
you say with hindsight it might have been done, but it's almost basic, isn't it, in any civil litigation that if you're putting forward your primary evidence, it comes from the best source rather than a hearsay description of what that source may say in a more widely couched document.
it does. It depends to some extent where one thinks the dispute lies.
Right.
The way that the dispute was developing, and this was the second hearing to deal with the matter, because we'd already turned up at the final order hearing, where it had sort of come out of the blue, as things sometimes do in final order hearings. One expected a continuation of the 3122 order in respect to the confidential information, and suddenly it was being objected to.
Right.
So the judge adjourned it, and we came back on a separate occasion to deal with the matter. But the way it had rather been set up is that, as the judge records in his judgment, this is formally Manitou's application for continuing 3122. But the force was from my learned friend who said all this information that we've been treating as confidential actually can be reverse engineered, and for that reason I'm free. So the level of evidence to say, look, this is confidential, one can understand why it was put on a lighter basis than it might have been had at the time we've been looking at this in a slightly...
My intervention has cut across the point my lord had asked you. My intervention cut across the point my lord had asked you.
I completely forget what that was.
I'm afraid I have to.
You were going to remind us of the evidence that you rely upon as
Yes.
establishing the confidentiality of heads 2 and 4.
Which was the core bundle.
Thank you.
No, the supplemental bundle, tab 7. And it was, no,
I think you mean tab 6.
tab 6, my lord, I'm grateful. And we were looking at it earlier. It's primarily in the context of paragraphs 15 is dealing with the 15 and 16 is dealing with those confidentiality of those subsystems. And then 18 goes on, 18 and 19 deals with the evidence as to the acronyms, I think.
19 in particular,
Just so that I understand what we're talking about, these subsystems, are they part of the software of the machine, or are they physically identifiable? If you reverse engineer it, you can spot that there's a number of these things on it.
I believe, my lord, they are functional items within the software,
That's
rather
right,
than
that's the way
a
I read it.
box and a box
Yes.
and a box.
So in a way, they if criterion X is the big feature, that may be understandable by reverse engineering, because that must be what is added to what would normally be happening. Head 3 is accepted to be confidential because actually that's the way you're achieving the result. These two sit halfway between the two. They're on the way to being part of what you're doing, and they're not the big picture. They're part of the cleverness, if that's the word, is that you're able to do it with whatever number it is, and measuring whatever those acronyms indicate you are measuring. Without, Mr. Heath Robinson might have constructed something similar with 15 or 34 different winches and pulleys. You've been able to do it in the way you've done it.
We've been able to do it clearly, and they add on the finesse to the basic concept, which gets you to a reliable commercial product.
Yeah. So in that way, it's part of, but different from Criterion X, which is the whole thing.
It's all part of the same story. You wouldn't use them without Criterion X.
Yes.
And they are part of our answer as to how you implement a reliable, safe commercial machine based upon Criterion X.
Yeah. And so rather than head 3, which shows actually how you do it, it shows how you're able to do it in, you would say, an efficient way.
If one was sitting down looking at a plan as to what I need to develop to make a Criterion X-based machine, I also need to have supporting here, and here systems that take care of some special aspects, which I won't go into. My Lord, I'm very aware that I've gone over time.
Right, so on your respondent's notice, you weren't going to take long. If you're not going to take much longer at all, obviously I think my Lord and my Lady will sit on for a very short time. Otherwise, we'll come back after the short adjournment.
I'm within a moment of finishing, so it's convenient that I do, which is,
That's all right.
there was evidence. My Lord and my Lady, or my Lord rightly comments that the evidence was on the thinner side, but the evidence is there explaining what these systems are and why they're considered confidential by Manitou. And against that, there was nothing. Now, it may be whether it's a balancing exercise when we come on to publication of the judgment, if we were considering 2 and 4, that there's a balance to be covered. But we're talking at this stage on JCB's appeal purely about the issue of confidentiality. They are internal matters. They are not published to anyone. They are not reverse engineerable. They are used for the operation of our commercial products. They meet all of the definitions of confidential information and trade secrets, and there is nothing against them. The judge was clearly right to accept that they were confidential. And really, the only contention that my learned friend has to try and say they're not is, oh, they fell, it was an understanding at the hearing for the judge that they fall with head 1. And we say that's where the parties were at the time. But the point that was being made to the judge was there was no evidence in respect of heads 2 and 4. And the transcript reference to that part of their case does not get off the ground. Is core bundle 13, transcript page 26, line 11 to 27, line 2. When asked what the position was on that evidence, it says they don't go off the ground. That was my position then and remains my position now. My Lords, I don't think I can assist further on my learned friend's appeal or my respondent's notice unless I've left anything which is concerning, and then come back after the short adjournment with my appeal.
Well, that's by pure chance, and no doubt skilled by both of you, gets us to the midway point of the case at half time. So that's obviously what we need. The clocks in this building, relatively. Shall we aim to be back for 2 o'clock?
Yes, my Lord.
Thank you.
Court will rise in April.